Good morning, and thank you for attending our webinar on the year ahead in labor and employment. We'll get started here in just a moment, but we have a few housekeeping items. Your mics have been muted for this segment, and we won't have time to address questions during this hour presentation. If you do have a question for one of our panelists, please add it to the Q&A function on your screen. We'll be sure to get in touch with you soon, and we'll also share the PowerPoint slides that you'll see today as well. And now I'll turn the program over to Chris Banaszak, who is Reinhardt's Labor and Employment Chair. Chris?
Good morning. Thanks, Donna. And we are happy that all of you could join us this morning. As Donna said, I'm the chair of our Labor and Employment Group. My work involves a wide variety of employment-related issues. I've been at Reinhardt now for a little over a quarter of a century. So I'll be speaking a little bit at the end about some hot topics or things that are likely to be coming up in the coming year in the employment area in general. And then in addition to me, we're very pleased to have with us Jason Gutzman. Jason is with Johnson Insurance. Has about, like me, more than a quarter of a century of experience in the employee benefits area. He does consulting work with employers of all sizes. He's actually from the Green Bay area, but because we're doing the webinar, we can have him join us remotely, which is great. He speaks regularly to different trade associations and employer groups on a variety of industry topics. And today we'll be talking about some key things that will be coming up in the employee benefits area. As many of you may go into insurance renewals and other things for the upcoming year. So we're very happy to have him joining us this morning. And then after Jason, we'll have Brittany Nolland, who is a shareholder in our labor and employment group here at Reinhardt. Brittany has received a number of different honors and awards over the years. She was named by the Milwaukee Business Journal as a 40 under 40 honoree. She's been in the Wisconsin Super Lawyers Rising Stars. She was selected an up and coming lawyer back in 2014 by the Wisconsin Law Journal, and has received a number of different awards and honors for her work. She also does work on a variety of different employment-related issues, and in particular has a focus on OSHA issues, employee safety issues, and is very knowledgeable about one of the hottest topics of the day, COVID and vaccines, and she will be talking about that later in the presentation. So without further ado, I will turn it over to Jason.
Thank you, Chris. That's for that great introduction. Good morning, everyone, or good afternoon if you're calling in from your yacht somewhere in the Atlantic Ocean. It's a real privilege to have the opportunity to spend a few minutes with you this morning and participate with the wonderful team at Reinhardt. As Chris mentioned, my specialty is employee benefits consulting and compliance here at Johnson. And what I'm going to do this morning is speak very high level on and share a number of observations and thoughts to help you prepare and or remind you of things relative to the upcoming renewal open enrollment season that many of you are embarking on. And other nuggets of information that might be new, particularly around the compliance area. So when you look at the three primary points, we're going to spend a few moments on healthcare cost drivers and projections. I'm going to talk a little bit about some strategies and make a few recommendations. And then, just as I said, some reminders on the compliance side. I recognize that any one of these items could be worthy of its own webinar, and I also recognize the demographics in the audience are diverse. So some things I mentioned might be real specific to you if you are self-insured. Others may not apply if you're a small group in terms of ACA definitions under 50. So it's very high level in general, but hopefully there'll be some information you hear that can be of value to you regardless. Brian, if you wouldn't mind maybe going to screen 5, please, the driver's screen. Thank you. So again, you're going to hear more about that C word, right? We're all tired of talking about it, but when it comes to the 2022 projections and what we've been seeing and hearing relative to renewals in particular, I've added a few bullet points here of just some themes that seem to be consistent regardless of where you are, fully insured, self-funded, small group, large group. COVID still continues, the pandemic still continues to have an impact. When it comes to the renewals, we've seen quite a few already come in for January 1st. And we're seeing trend from carriers ranging in that 7% range. There are obviously exceptions to that, and there's geography and demographic variables as well. COVID, although it is still a factor, it does not appear to be as significant of a factor as it was a year ago. Looking at renewals, even with the Delta variant and the recent surge, the spend is not nearly what it was at this time last year, as well as the uncertainty level. One thing that's come out of this that's very positive really is the use of virtual care and telehealth, and those resources or outlets for care continue to be prevalent, and a lot of healthcare systems, a lot of insurance carriers and others have continue to invest in enhancing that experience for members, and that can be expected to be continued. When we talk about the trends that I mentioned earlier, for percentages, again, the trend factor in and of itself is really specific to medical inflation as a variable within the renewal itself. So if you get a 15% increase on your rates, the trend component of that will be in that range for PPO, POS plans, which is where most people are. It's slightly lower for HMOs, and of course there's some geography there as well. And specialty drug continues to be a huge piece of renewals, as well as stop loss, the stop loss market and the impact it has. So that is not going to end anytime soon. And in a little bit, I'll mention just some thoughts around prescription spend in particular. Cancer continues to dominate when it comes to cost and frequency, high cost claims for members. I mean, that's really the diagnosis of concern when you're talking to an underwriter. An underwriter is putting the pen to paper for renewals. And last but not least, unfortunately, unless you've been living in a cave, you're well aware that a byproduct of the pandemic has been a dramatic increase in mental health, behavioral health, and substance abuse issues. Frankly, I'd suggest that this is we're at or very close to an epidemic level when it comes to the volume of claims and the utilization of care external to the health plan, such as EAPs, and that's unfortunately not subsiding at this time, and certainly something to keep an eye on as you head into 2022. Next screen, please. This is just extracted from a survey that Zywave out in Milwaukee prepared. It's a survey I like to use as a broker every year. It is unique in that I'm not aware of many surveys that are very heavy upper Midwest in terms of respondees that asks them about the things they value and look for in their relationship with their broker. But in this 2021 version, they ask questions relative to challenges, and I always like this. when I'm talking to businesses about to understand really what their focus is, and that helps then discuss strategic plans and ideas and around what's important to them. And what I really find interesting on this screen is that, you know, the costs aside, which we'll always see cost mitigation as number one, right? But there are a lot of other ranked high in importance to employers when it comes to just staying aware of what's going on from a compliance standpoint. The human capital side, we'll talk a bit more about in a bit, but attracting and retaining employees is front of mind for all employers, regardless of industry right now. And overall, just helping employees understand their benefits, understand why costs are the way they are, helping educate, really instilling that consumerism mentality. That continues to be a real common theme. And you know, in the past years, this survey would be real heavy on you know, employee cost sharing and medical plan design, and a lot of things that are kind of the Band-Aid on the broken leg approaches to getting your arms around costs and insurance in particular. But this seems to reflect a trend in a direction of just more revolving around human capital and employee engagement and understanding and awareness. Next screen, please, Brian. Now, tying that all together, and as I mentioned, any one of these points we've talked about already, and moving forward could be an hour onto themselves, and this screen is no exception. These are just some things that I'd like to throw out there to you to consider if you haven't already. That, you know, I'm talking to a lot of my clients about when it comes to just being prepared and proactive and being innovative. When it comes to mitigating those costs and again, addressing that human capital side. But specific to the insurance, a lot of these ideas are not brand new, but many of them have taken great leaps forward in terms of their prevalence and the levels of interest with employers. And if you're fully insured, you know, I say escaping that vicious cycle of fully insured, really that's just finding alternatives to that funding mechanism that might put you more in control of your spend, give you a chance to bet on yourself, potentially have a better, greater say in plan design and such. In the most common alternatives to fully insured, one is level funding. Level funding I call self-funding with training wheels. It's basically a hybrid of the fully insured mechanism and the self-funded mechanism. It gives one a chance to essentially dip their toes in the water of self-funding while maintaining some of the predictability and comfort in the fully insured side. Definitely growing in popularity. Many carriers that had not been offering products in that realm have started to, recognizing it's very popular. Many carriers will go down to as few as 10 employees now when it comes to level funding. Traditional self-funding has been around forever, right? Again, continuing to grow in popularity year in and year out. There hasn't been a year in at least the past decade where self-funding has decreased in terms of employers choosing it as a funding mechanism. The traditional method, obviously using a third-party administrator and PBMs, prescription benefit managers, PBMs, other pieces to essentially build out your benefit plan. I spend a lot of time, and we do as an organization, talking to employers that are familiar with self-funding about considering the captive approach to self-funding, essentially grouping yourself with other like-minded employers to gain the various efficiencies and leveraging abilities. And there's a lot more to captives, but I think that is definitely an area to look at if you've been traditionally self-funded and would like to, again, take opportunities to improve your ability to obtain pricing advantages and things that you get as part of a larger group versus being on your own island. Reference-based pricing, not new, but growing in popularity, still not as strong in the state of Wisconsin as it is in other parts of the country, like in the South, Texas, for example. But definitely has its place in the market, and it will continue. And by reference-based pricing, essentially we're talking about is developing a plan that reimburses providers similar to the levels that they would be as taking assignment from Medicare. It's controversial, there's pros and cons, but it certainly has its place, and it appears to not be going anywhere. Something to talk to your broker about for sure if you're looking to get a little more aggressive. Site of care alternatives, we talked about virtual care and telehealth, its popularity. Just continue to reinforce its availability to your employees and their family members. On-site, near-site clinics, another really hot topic that we're talking to a lot of employers about, especially those in the self-funded arena that, again, like to band together with other employers and form a near site to offer primarily non-invasive types care, treatment, preventive care and such, or host their own clinic for their associates. And of course, that last point on the previous screen, sorry, a couple screens ago, regarding the mental health and substance abuse challenges we have. Promoting and enhancing your EAP services goes without saying at this point in time, and what better time than in open enrollment to do so if you're embarking down into that at this point for 1/1 or 12/1. And then I mentioned prescription drugs earlier, prescription drug spend. Just some nuggets. Again, if you are self-funded, you do obviously have a lot more control than you do if you're fully insured, but even fully insured carriers are offering different formularies and structure and things around cost containment, and just in and of itself, prescription costs are inflating at a higher level than general healthcare. And it just does not appear to be ending anytime soon. So take a close look at that part of your benefit program. If you're self-funded, I strongly encourage tearing up or digging into your PBM contract and stay away from the multi-year contracts. With things changing as fast as they are, signing something that commits you to a structure that's 2 or 3 years out, it sounds great because you can put it away and not think about it. But because things are changing so fast and pricing changes so fast, it's definitely to your advantage to annually redo a contract with either the current PBM or at least shop around, because it's very competitive, and you will have a chance to improve on rebates and wholesale pricing and such by annually taking a look at it. And then earlier this year, or this summer, the president issued an executive order that was heavy on healthcare, and there's just some provisions in there specific to prescription drugs that I just would encourage people to monitor and stay on top of. In particular, there's the potential of opening up importation from Canada. There is going to be a ban on the pay for delay game that prescription pharmaceutical manufacturers play to avoid competition and delay competition in the market. There's also going to be some things like hearing aids being able to be purchased over the counter, and other transparency related elements to really help us all be in the prescription side of healthcare. Next screen, please, Brian. And then just switching over to just some regulatory and compliance updates. I chose a few things here to just remind people about. Every year, there's an indexing on out-of-pocket maximums for non-high deductible health plan, non-grandfather plans, and I'm just illustrating what the 2022 limits will be as a reminder. If you haven't already, we're getting close to that deadline for getting that annual Part D notice out. If you haven't, just know the template hasn't changed. It's been unchanged for quite some time. You either are distributing a credible notice or a notice that says your prescription coverage is non-credible. That allows those then who are who are delaying Medicare enrollment to have that evidence if they need it, if something happens and they need to enroll. And then, of course, the reason the deadline is set where it is because right after that date is when the floodgates open annually for people to take advantage of the Medicare Part D open enrollment period that begins. The next point is really important, I would say to you, if you are embarking on open enrollment and renewals season, usually the word decrease is a good thing. And when it comes to affordability for the pay or play side of the Affordable Care Act, know that that threshold for affordability is actually decreasing by 0.21%, which doesn't sound like a big number, but I have a lot of clients who kind of straddle the fence when they're choosing their employee contributions for their plans for the new year, and that percentage gets a lot of attention, and it is going down a tick. So just be aware of that when you are finalizing decisions and turn the page over to what employee shares will be to avoid any unintended consequence of ACA penalties. Unfortunately, the nightmare that never goes away, the ACA reporting, everyone's favorite thing, is still here to stay, and I would argue it. Especially with the most recent Supreme Court ruling on the ACA in general, that this provision is not going away, and as long as there's a penalty aspect tied to it for pay or play, it serves a purpose. Unfortunately, it's not changing. There'll be more to come soon in terms of the different codes or any changes to the coding, but just know that for the 2021 year, there will still need to be that section 6055 and 56 reporting to do internally or through your third-party partner. Next screen, Brian. Real quick, ACA penalties, we mentioned, the affordability is one side of it, but then there's the pay or play side, and that also is indexed every year. So there's some information here for you on that. New to be aware of for 1/1 is going to be the No Surprises Act. There are certain pieces of this, and this comes from the Consolidated Appropriations Act that was signed late last year. But be aware that the No Surprises Act does have some impact on benefits per se, whether you are self-funded or fully insured, in particular, how out-of-network claims for emergency services, for situations where you have care rendered at a facility or in-network hospital done by non-preferred providers, care tied to non-preferred providers provided in a facility that is in network. So example, surgeries where an anesthesiologist might be out of network. And then air ambulance is also kind of the third piece where there'll be changes in terms of how those claims are adjudicated. Again, that topic is broad, and we could talk about that for quite a bit, but just wanted to share a couple nuggets here on that. And there are other pieces of the No Surprises Act to be aware of that will affect things like our ID cards and EOBs, explanation of benefits, in providing us with tools as well to do real-time searches on benefit levels and things. So there's a lot more that you'll hear about with the No Surprises Act. If you haven't already, be sure to talk to your broker consultant about that more if you are renewing on 1/1. And pay attention to what you hear, because there are some things that you might get questions on from your associates that you'll want to be aware of. Next screen, Brian. This is also a visual for anyone who didn't already know about the 22 limits specific to high deductible health plans and HSAs. I guess the key things are what's changing. And on the far right, you'll see there's a slight tick up on our contribution limits for 2022, and the out-of-pocket maximums for high deductible health plans, which, as a reminder, do differ from the non-HDHP plan designs, which I mentioned a few screens back. You can see what the limits are, and they're going up slightly. Waiting on official for FSAs, the healthcare reimbursement Section 125 plans. Normally late in the year, we get something official from IRS. Most prognosticators feel that we're going to see a $100 increase from $2,750 up to $2,850 for 2022. And if you have a carryover provision in your FSA, that too may slightly uptick. I'm hearing $550 up to $570. Remember that for this year, that carryover was unlimited as a temporary relief tied back to the CAA. That was not intended to be ongoing, so that may grandfather out. And we'd go back to what we had before, which was a carryover maximum limit. Again, $550. That probably will go up, hearing $20 or so. Just a sidebar on that. And then just last but not least, on the next screen, Brian, I just want to share with you, a part of my role at Johnson is I am our compliance specialist as well. So I spend a lot of time talking to clients and my peers and helping putting clients through compliance and regulatory compliance audits. And this is kind of a checklist of the things I see most often overlooked. And I don't want you to end up missing on any of these. They're all important. They all could be problematic if you find yourself in an unfortunate situation where the EEOC or DOL are knocking on the door. Some of these I mentioned, like the No Surprises Act, there's going to be a piece tied to that regarding independent dispute resolution. More so for you if you're self-funded, be talking to your broker, consultant, or TPA about the IDR component of the No Surprises Act. But the rest of these are pretty straightforward. COBRA rates always are important, but what I find a lot are people's forgetting to include health reimbursement arrangements, HRAs, EAPs, and on-site or near-site clinic components that are also subject to COBRA, as they are quote unquote health and welfare plans providing bona fide healthcare. RISA wrap documents, if you don't have one, probably something to talk to your broker consultant about. I would strongly recommend one, whether you're subject to 5,500 filings or not. There's a lot of advantages and efficiencies to having a wrap. And then some other things you see there, just more or less reminders. The last one, if you're self-funded, I'd consider strongly talking to your broker consultant or TPA about getting a non-quantitative treatment limitations assessment done on your mental health substance abuse benefits. EEOC has really ramped up its auditing and complaint mechanism options for people to challenge those pieces of benefit plans. Again, the other items here, I'll just leave for you for the sake of time to take a look at. At the end of the day here, before I pass the baton on to the main event, I would just like you to know, next screen, Brian, that if there's anything I can do for anybody offline, any questions, any second opinions, soundboarding, no obligation, just want to get an opinion on something, by all means, do not hesitate to contact me at email or phone that you see here. And again, I thank you for the opportunity to take a few minutes to be part of your busy day, take a few minutes out of it. And with that, pass the baton back to you, Chris, or Brittany.
All right. Thank you. Thank you very much, Jason. And I will turn it over to Brittany, who will again be talking about some COVID-19 and vaccine issues. Brittany?
Yeah, hi, thanks, Chris. Thanks, Jason. It's great to be here today. Brian, if you want to go ahead and jump to the next slide. So today I am going to be talking about some COVID-19 related issues in the workplace. And, I know that everybody's getting a little bit sick of it, but hopefully we're kind of getting through it. We're obviously having a lot of information news about vaccinations. And the first question that always comes up is, can employers mandate the vaccination in the workplace? And the answer to that question is, yes, you can for at-will employees, provided that you are making accommodations as appropriate. So as it noted, not all employees will necessarily be vaccinated. So if you want to jump to the next slide, the big news with vaccinations obviously is President Biden's COVID-19 action plan that he announced on September 9th. And there are several portions of that plan that may impact employers. The first one, the big one, is for private employers. He said that those with 100+ employees will be required to ensure that those employees are either vaccinated or tested weekly before reporting to work. In addition, employees must be paid for their time off to get the vaccine and recovering from any side effects. OSHA has been tasked with promulgating this rule, and they'll do so under their authority to issue emergency temporary standards. And we're a little bit in the waiting room on when that will come out. My understanding is that OSHA had 1 week notice of the proposal, and normally it takes them months to come up with an ETS. The healthcare ETS just came out in June after being announced in January. So hopefully this will move a little bit more quickly, because it's really left a lot of open questions for employers at this point. Employers are wondering, how do they count their employees to know whether this is going to impact them? Are we counting only in-office employees, or do we have to count telework and remote employees? Do we have to count every part-time employee? And in terms of the weekly testing, who has to pay for that? Is that something that employers will pay for both the testing and the time? And if there's not guidance, there may be some conflict with state laws. So a lot of open questions that we will be providing answers for once that rule comes out. There most certainly will be a legal challenge. You have 60 days from the publishing of the rule to submit challenges. There will likely be challenges about whether there is a grave danger, which is what is required to issue an emergency temporary standard. And I anticipate that there will also be a lot of questions about the 100 employee threshold and whether that's reasonable, whether, you know, a workplace with 90 employees is at any less of a danger than one with 120 employees. So we'll have to sit tight on that for now. And I'll get in a few minutes to some things we can do in the interim, though, while you're waiting. Another type of employer that may be impacted by the COVID-19 action plan, if we jump to the next slide, is federal contractors. And federal contractors are going to be required to ensure that all employees covered by the contract are fully vaccinated by December 8th. So unlike private employers, there is not an option to vaccinate or test weekly. These employees must be fully vaccinated unless they are entitled to an accommodation under the Americans with Disabilities Act or Title VII. This statement on federal contractors just came out on the 24th. A few other provisions of that may be interesting are that it applies to new contracts, but agencies are also encouraged to incorporate it in their current contracts sooner. So just because you don't have a new contract coming up or a renewal, the agency you're working for may still require it. Employers have to see proof of vaccination. So there's no honor system or, you know, attestations that are going to be allowed. It also includes telework and remote employees. And the apparent thought process on that was that while they may be remote, at some point they may have to come into contact either with the public or with others on the project they're working on. And so as a result, those employees do need to be vaccinated also. The final point is just reiteration that federal contractors need to comply with CDC guidance on masking and social distancing. The other area of a vaccine mandate is that President Biden has instructed the Centers for Medicare and Medicaid Services to also issue a rule requiring vaccinations in most healthcare facilities as a condition of participating in Medicare and Medicaid funding. Those rules have not come down yet, but again, we should be keeping an eye out for those. So if we think about what we can do in the interim, whether we're going to potentially be subject to a vaccine mandate or what has been referred to as a soft mandate, the vaccinate or test, one of the things that you can do ahead of time is assess what portion of your workforce is going to be impacted by this. So you're entitled to do a survey about vaccination status. You're entitled to request proof of vaccination. What I wouldn't do at this point is ask why people aren't vaccinated. You don't want to start getting into potential medical information at this point. But if you want to assess, you know, what percentage of your workforce is vaccinated, what percentage potentially will get vaccinated if mandated, and who may opt for that weekly testing if that is something that will be permitted for you. Also educating employees on the rule. When the headlines came down for the private employer mandate, everything said vaccine mandate. So we had a lot of employers getting questions from employees saying, hey, you know, I've been very clear that I'm not going to get vaccinated, and not understanding that there may be this option to do weekly testing. The other big thing to think about is making sure you're prepared to handle accommodations. So, you know, making sure that if you have a large staff and you might need more than one person, that everyone's trained, everyone knows what they're doing, and you understand what kind of documentation you're going to be requesting on that issue. So if we jump to the next slide, in the event that an employer chooses or is required to have some sort of vaccine mandate or for employees may request an accommodation, as I mentioned, under the ADA or Title VII. And most employers are pretty familiar with the ADA process, where an employee requests an accommodation because they have a medical condition that prevents them from getting the vaccination. Employers will go through the interactive process to assess whether there is a reasonable accommodation that won't result in an undue hardship to the employer. And for purposes of the ADA, that undue hardship is a substantial or disruptive burden, a significant financial burden, or something that fundamentally alters the nature of the business. So it is a high standard. So employers really do need to assess what some potential options are and go through that interactive process and work with the employee to see if there is a way to accommodate them. The Title VII accommodations are a little bit more rare, particularly here in this instance. You know, sometimes accommodations may seek different scheduling to accommodate religious services, or, you know, things like that. And so here you may have an employee that has a sincerely held religious belief that they say prevents them from being vaccinated. And this is, the EEO's position is we should give employees the benefit of the doubt when they raise this issue. But that doesn't mean that employers can't ask additional questions regarding the sincerity of the belief. And if they have some doubts, they can ask for additional information and documentation. But employers don't want to set specific requirements, such as saying, you know, we'll only grant these accommodations if you have a letter from your, you know, religious leader. That is not a requirement that employers should make on employees, as some individuals may have sincerely held religious beliefs that may be somewhat divergent from, you know, the thought process of their mainstream church. So this, when you're considering these, if you've decided that there is a sincerely held religious belief and you're looking at accommodations, this is a slightly different assessment. So here, it's still, is there a reasonable accommodation that can be provided without undue hardship? But the level of undue hardship is much lower. If the accommodation imposes more than a de minimis burden on the employer, they may not need to provide the accommodation. And there is some precedent saying that, you know, imposing a safety risk for workers is more than a de minimis burden. So assessing, is there a way to have that employee safely performing their job functions that's not posing a risk to other employees, is the lens you kind of want to look at these requests through. If we jump to the next slide, another potential accommodation issue is long haul COVID, or where the symptoms of COVID-19 kind of linger, whether it's the brain fog, fatigue, lung issues. These may qualify as a disability under the ADA if it substantially impacts one or more of an employee's major life activities. And so, you know, you want to just make sure you're continuing to review a request for an accommodation as a result of long-term COVID, as you would with any other request on a case-by-case basis, and not, you know, making snap judgments one way or another about that. Next slide, quickly to touch on kind of skewing away from vaccine mandates and looking at vaccine incentives. We've had a little bit of back and forth this year. The prior guidance on vaccine incentives was pulled in January. In May, the EEOC confirmed that employers can offer incentives to receive the vaccine or to provide evidence of their vaccination status. The EEOC does make a distinction between incentives offered for verifying that you were vaccinated by a third party or encouraging employees to be vaccinated by the employer or the employer's agent. So for third parties, the EEOC said we're not concerned about those incentives, but if you are offering incentive for your employee to be vaccinated by you or by your agent, those vaccine incentives cannot be so substantial as to be coercive, which if it sounds a little bit vague, it is. So that is, I wish that we could say we had something really clear, like we had a dollar threshold. We don't. It's a standard that seems like it could change based on, the wage or salary levels of the employee. Like what is going to be so substantial as to be coercive may vary. The EEOC's prior guidance suggested kind of de minimis incentives like water bottles or gift cards of, $20, $25. So you want to be aware of that if you are administering the vaccine as the employer or using an agent, that you're going to be more restricted in terms of incentives. If we jump to the next slide, another kind of accommodations tie-in is accommodations for remote workers. And as we see vaccine numbers rising, we're potentially seeing some of those return to work plans get back on track. I know a lot of places we're looking at July, August, September, and maybe have now pushed it off to January. And so as we're looking at coming back, one of the best things you can do is be proactive in your messaging on it. If you want people back January 1st, give them some time to kind of process that, make plans, if they will change childcare or whatnot. And the other thing that's helpful by giving them some notice is assessing what accommodations they're going to need as they come back into the office. Kind of unrelated to COVID, you may have employees that have developed medical conditions in the interim and may need an accommodation where they didn't previously. You may have an employee that had previously requested an accommodation you rejected, and they may be renewing it, and you want to reconsider that without just kind of outright saying, we looked at this 2 years ago. And that comes from the EEOC noting that this period of telework for many employees kind of has acted as a trial run. So you want to look at whether or not, in light of this kind of new evidence over the past 18 months, could employees perform their job function remotely or partially remote, and just make sure you're focusing on that in light of your new assessment. It's particularly relevant. The EEOC has recently filed its first lawsuit addressing this specific issue. An employee didn't want to return to work in person, wanted to continue working remotely, and that request was rejected. And so the EEOC has brought suit on her behalf. It's not clear from the complaint what the employer's basis was for rejecting the request. So, that issue is out there. Just make sure we're looking at what the past 18 months have taught us about certain employees' ability to work remotely. But again, that's not to say that remote work is always an option. A lot of employers permitted remote work, even though it really did impair the ability of some employees to do all of their essential functions. So just keep that in the back of your mind as you're processing those requests. One other issue that we've noticed with a lot of employers is with remote work, employers have been kind of able to open up their applicant pool. We've been able to look for employees on a larger geographic scale. And as a result of that, you want to make sure that you're fully aware of any potential state and local laws that are covering you. And the big one is, out-of-state employees. So if you have hired a few employees in Illinois, let's make sure that we understand what sort of additional employee protections they're entitled to. There are some additional leave policies that Illinois employees are entitled to. And the same with, obviously a lot of people know if you're hiring someone in California, a lot of employee protections, additional training. So just make sure that you are fully aware of where your remote employees are working. That way you can assess that you are fully compliant with laws, that you are, addressing tax, unemployment, workers' compensation issues in those states if needed. A couple other COVID-specific issues. Some states have more restrictive requirements on expense reimbursement. So particularly Illinois, California, there's a handful of others. Any job-related expenses are required to be reimbursed. So that's one of these questions that may come into play with weekly testing, is if you have employees in those states that you're thinking about that, about whether that's going to be a cost that you may need to incur. So just a couple best practices with remote work. Make sure you have clear policies on remote work. Who can work remotely? How often? What kind of notice? And are there any requirements for why people can work remotely? Some places have, for bad weather and personal emergencies, we may permit it. But let's make sure that's clear from the outset and being applied consistently. Your time recording and tracking policies for remote workers. So if people should be working on their schedule, make sure that that is clear. And if they're working outside of their schedule and it's not appropriate, they should still be paid, but we should be disciplining if they should not be working those hours. And then again, just account for where your employees are working. That way you understand all of your obligations with regard to those employees. And that is it for now on COVID. I will turn it over to Chris to give you a few more updates for 2022.
All right. Thank you, Brittany. So I'm just going to highlight a few things that are on the horizon. I think a lot of the activity is at the legislative and executive level that are either out there right now or likely to be coming up over the next year. So Brian, if you want to turn to the next slide. And there are some areas in Congress where there's likely legislative action that is, some cases is already passed one house. There's also a big push regarding non-competition agreements for those of you who have employees who are subject to those at both the federal and state level. And then I'll just highlight a couple of Supreme Court cases. There actually are not too many significant cases currently on the Supreme Court docket that relate to the employment area, but there are a couple. Brian, if you could turn to the next slide. So at the federal level, in terms of legislative action, one of the things that's out there is increasing the minimum wage. That has already occurred or will already occur for federal contractors. President Biden signed an executive order that would set the minimum wage for federal contractors at $15 per hour and $10.50 an hour for tipped federal workers, and that's set to take effect on January 30th of 2022. In addition to that, there are approximately half of the states that are looking at changes to minimum wage. At the federal level, it was a campaign promise from President Biden, and there are congressional Democrats who are looking to increase the federal minimum wage. So I would look for more activity in that area over the upcoming year or two. The other issue related to wage law is the salary threshold for exempt workers, which went up not too long ago. There's discussion about increasing that further. When the initial plan to change that came out, there was actually a much higher level than what they ultimately moved to under the current regulations. And I think the push here is to move it back up to that higher level potentially, although there hasn't been any specific action on that currently. One other area at the federal level that's seen a lot of activity is the PRO Act, which stands for Protecting the Right to Organize. That would, if that were to go into effect, would make some significant changes to US labor laws. Just some of the highlights of the bill: it would override state right to work laws, which allow employees who might otherwise be covered by union contracts to opt out of paying union dues. So this would change that at the federal level. It would change certain things that employers are allowed to engage in terms of having influence in union elections. It would create some penalties, monetary penalties, in some cases providing for personal liability for violations of workers' rights laws, and in general would strengthen union and worker rights. So we'll see what happens with that. One other area of legislative action at the federal level is paid sick leave. As part of the COVID-19 legislation, there was a leave provision under that applied to individuals who had COVID. A lot of people saw that as kind of a trial run for a broader paid sick leave act. There's some legislation that's under consideration. One of the proposals would allow someone to receive 2/3 of their wages paid for up to 12 weeks. The details of that have not come out yet, but again, I think that's something that is likely to come up. One other area, Brian, if you can move to the next slide, that has seen a lot of activity is non-competition agreements. And some of this even goes back a little bit further. There was a memo that the Federal Trade Commission put out back in 2016, dealing with agreements between companies related to the hiring of employees. And the memo essentially said that companies cannot do that. You can't have an agreement with another company not to hire one another's employees, and that that would be a violation of antitrust laws. And they've been fairly aggressive about enforcing those. Previously, if they did try to enforce it, it was a civil enforcement action. They have fairly recently filed some criminal cases against individuals who allegedly engaged in that activity. So, that's something that is an area of scrutiny. And the memo sets out in some detail, what they believe people should and should not do and can and cannot do. And sort of related to that, in the competition area, at the state level, there are many states that have implemented new laws that restrict or eliminate the ability to have non-compete agreements with individuals. Illinois, Washington, D.C., Nevada, Oregon, all passed new laws in 2021 dealing with those issues. A lot of them are focused on lower wage workers. There may be wage or salary thresholds where you're prohibited from having individuals who are below a certain level from signing those. And so that's something to pay attention to, especially as Brittany mentioned with remote work. If you have individuals who are working in different states, they may be subject to different state laws that govern non-compete agreements that are different than where the corporate office is located for a company. There will also likely be action on non-competition agreements at the federal level. President Biden issued an executive order that encouraged the FTC to do some rulemaking in this area. It's not clear exactly what that will be at this point. He's encouraged it, but it doesn't provide a lot of specifics as to what type of action they ultimately will take at the federal level. But I think in general, there are going to be a lot more limitations that are put in place. And, it's important with non-competition agreements in general to review them fairly regularly, because there are changes to the law. And I think the pace of the change of the laws that apply to those is going to accelerate dramatically over the next year or two. As I mentioned, if you go to the next slide, Brian, there are not a large number of cases that are pending before the U.S. Supreme Court this year that are employment related. Just to highlight a couple of them, One is Cummings versus Premier Rehab. That case considers whether the compensatory damages that are available for claims under Title VII can include compensation for emotional distress. If the court were to find that it does, it would increase the potential liability for violation of discrimination laws. One of the other cases, CVS Pharmacy versus Doe. That case, the issue is whether disability discrimination laws allow disparate impact causes of action, which in some cases can be easier for an individual to prove. And so, it may change the claims that are available for alleged disabilities, depending on the outcome of that case. The other case that's mentioned in the PowerPoint here is White versus United Airlines. That's actually a Seventh Circuit case. This case came out the past year. There are similar cases in other circuits considering this question. In that case, the Seventh Circuit held that USERRA, which requires an employer to provide military leave, also requires that leave to be paid if the employer also provides comparable paid leave. So in other words, if you had someone you were providing military leave to, and you paid employees for other types of leave that are similar, you may be obligated to pay them for the military leave as well. And that, again, that's a Seventh Circuit case. It's most significant for employers who are in Wisconsin, Illinois, and Indiana. So those are, again, some of the highlights of employment-related issues that are out there and will be coming up over the next year. And that concludes our program. We appreciate very much you taking the time to join us. As Donna said, if you have any questions, please submit those online, and we will try to get back to you as promptly as we can on those. And again, thanks for the opportunity to talk to you, and have a great day.